Good morning, everyone, and welcome to the fifth and final webinar in our April Asset Management webinar series. My name is Gary Fitzpatrick. I'm a principal in the Asset Management Assurance practice here in KPMG Dublin, and I'll be your moderator for today. So just before we get into the content we've prepared for you today, just a quick recap on where we're at in the series. So we've had 5 webinars over the month of April. We started with a webinar around fraud and procedures around fraud. We then went on to navigating change with key trends in asset management. We then talked about human rights and supply chain due diligence for asset managers. And last week we focused on Pillar 2 considerations for investment funds and covered some aspects of securitizations there as well. And today we'll focus on legal and regulatory update from KPMG Law. All of the previous webinars are available to view through a recording link, and that link should be available in your interface there today. So feel free to watch them in your own time if you've missed any of the previous webinars. So just before we move on to the content, everyone's probably quite familiar with the platform now, but just to explain exactly how it works for anyone that might be new to the platform. It's an interactive platform, so you should have a Q&A function on your screen. So if you want to ask any questions during the course of the webinar, please feel free to do so. And Chris and I will try and pick them up at the end of the session where we have 5 minutes allocated for Q&A. If we don't get to them, don't worry, we'll respond to them accordingly through your email. So you will get a reply to any questions you have. You can also use reactions as well. So that there's reactions you can make. You'll probably see them on your screen as well if you like any of the particular content or any of the particular discussion that takes place. You'll also see speaker bios as well for myself and Christopher Martin as well. So that's just a bit of an explanation on the platform. So today we're going to focus on legal and regulatory update from KPMG Law. And I'm glad to say I'm joined by a colleague of mine, Christopher Martin, who is a partner in the KPMG Law Financial Services Regulation practice. So there's obviously a lot on the agenda from a regulator point of view, from both our local regulator, which is the CBI, of course, and of course coming down from ESMA, which is the European regulator as well. And Christopher is going to cover the key aspects of that agenda and kind of the key developments and things to watch as the landscape continues to evolve. So without further ado, I'll hand over to Christopher and we'll regroup at the end for a short Q&A. Good luck, Christopher. Thank you.
Thanks very much, Gary. So as mentioned, we've a fairly packed agenda for this morning, just obviously for 30 minutes. So we'll have a look at some of the key funds takeaways from the Regulatory and Supervisory Outlook report, have a look at the recent enforcement action against Waystone Fund Management, a very brief overview of the ongoing MiFID II and MiFIR reviews, the fitness and probity consultation, some of the developments on the RTS in terms of the AML package, and lastly, a bit of horizon scanning in terms of FIDA, so the Financial Data Access Regulation. So firstly, having a look at the Regulatory and Supervisory Outlook report. So this was released by the Central Bank at the end of February, so only a couple of months, and obviously it was dealing with not just funds, but the broader financial services industry. The key kind of takeaways or key focuses from a general perspective were very much looking at the potential impacts around AI, as well as some of the geopolitical issues and circumstances currently, obviously very relevant from a macro potential perspective. But taking a look at the specific takeaways in the funds industry, the central bank was very clear that it views that there is certainly a heightened risk of cyber attacks and disruptions, obviously a need for continuing vigilance and enhancements to barriers and adequate stress testing there, obviously feeding very much into its broader focus on DORA and operational resilience more generally at the moment. In terms of ManCo governance, we also see an ongoing focus on delegation and outsourced activities. And I think one of the things that the central bank has called out there is obviously an increased focus on white label management companies, given, in its view, the growth of this particular business model. From an AML perspective, the central bank did note that the funds sector itself has been effectively labelled as medium high. And the reasons for that are obviously driven by complex structures, potential lack of transparency around ownership control, and particular issues where bank and custody accounts are offshore, and then the general ongoing deficiencies in AML controls, etc. So I think one of the key takeaways, obviously, from that particular point is funds and their mancos should be very clear in terms of their own business risk assessments, but the sector has been classified as medium high and build that in to their risk assessments together with appropriate mitigating factors to try and reduce the overall and inherent and residual risks associated with their products and services. In terms of ESG, in particular, I suppose, sustainable finance, the central bank has noted that there's been a bit of a downward trend in Article 9 funds, but there has been a bit of an uptick in Article 8 funds, noting that this is possibly due to what it's referring to as green hushing. So in other words, people kind of downplaying some of their green credentials in order to, I suppose, minimize some of the regulatory burdens around it. But the central bank is also still very much focused on making sure that where funds are claiming that they are sustainable, that they can support that. An ongoing issue, which the central bank again has raised, is the quality of data in connection with the financial returns and general returns to the central bank. The central bank's view is that this is often due to inadequate data governance practices. What they've said is, look, in circumstances where this is an issue, firms will face heightened regulatory scrutiny and obviously potentially additional regulatory action. So that could include up to enforcement action, but also could be things like risk mitigation plans or other requirements to put in place additional systems and controls. I think an interesting thing, given the broader focus of the Outlook report on the use of AI in financial services, is, I suppose, the central bank's feedback in the funds industry was that currently, in its view, the use of AI is being relatively limited, certainly in the context of portfolio management, but there is the potential for benefits and obviously risks there. And one of the crucial needs will be, if it is deployed, that there is human oversight in connection with those activities or those management functions. Lastly, the central bank did note that there's been increased engagement from funds looking to invest in alternative assets. So that's included crypto assets, as well as private debt and collateralized loan obligations. So you can see there's been a fair bit of movement and ongoing scrutiny on the fund sector, particularly around AML risks, outsourcing, some of the perennial issues, as well as the ongoing focus on data quality and the use of AI. So moving on to the second point. So there was a relatively recent enforcement action against Waystone Fund Management Limited, and the penalties were imposed there in November of 2024. Worth mentioning, I think, in fairness to Waystone, but the actual fund management company that was investigated and had the issues was actually purchased by it back in 2020, and they changed the name in 2021. It's since kind of handed over all of its existing fund management activities to another Waystone entity in the meantime. But effectively, what happened in this case was what was then Montlake Management Limited, but was renamed later Waystone Fund Management IE Limited, appointed an investment manager to manage certain illiquid assets. In this case, it was a number of loan notes. And what they did was they relied on previous due diligence they had done in respect of this particular investment manager, but the investment manager previously had only really dealt with quite liquid assets. So they relied on that, appointed him. What they didn't do was additional due diligence, and so they didn't pick up initially that the issuer of the notes, who was the only source of valuation for these notes, was also a senior executive in the investment manager they were appointing. So that mutual ownership therefore created obviously concerns in terms of conflicts of interest and reliance on the valuations being provided. So these kind of issues were picked up ultimately by the auditors in late 2019, and the fund obviously ultimately sought to get the funds returned from it as a result of those issues that had been identified in terms of the fund valuation. Unfortunately, they only ultimately managed to get about 40% of the investment returned on these loan notes, and ultimately they suspended dealing in the fund on the 4th of August 2020. So they then notified the central bank at that stage, obviously quite late, and the central bank then looked into it and ultimately proceeded to enforcement action. So in fining the firm, see they fined them about €395,000 after the 30% discount, so it was much more, extra 30%. But the central bank essentially called out a number of key issues with what occurred, which was firstly, as I mentioned, this issue around particularly that they were relying on older due diligence which related to different nature of assets that were being managed. Previously liquid assets, in this case it was illiquid loan notes, and they didn't effectively monitor that delegate when they were carrying them out. They didn't manage to identify or manage the conflicts of interest associated with this particular issuer and the investment manager, noting that there was kind of mutuality of ownership. There were inadequate risk management systems. They didn't have appropriate and consistent approach to valuation in place. As I mentioned, obviously it was quite hard to value these loan notes given their illiquid nature, but they also didn't have an appropriate procedure in place to do that. And they also failed to disclose their valuation procedures to the investors. The central bank also criticised them heavily for failing to notify the central bank of the breaches of the AIFM regs, obviously when they became aware of potential issues back in late 2019, and they obviously didn't treat the investors fairly or act in their best interests, ultimately because they only managed to return 40%. I think in terms of key takeaways for funds, I think a key element to this is making sure that where you are engaging third parties, you've done sufficient due diligence, both that is relevant to the immediate products that will be under management. So again, in this case, the distinction between the liquid and the illiquid assets under management, and that you have a good understanding of any relationships that that entity may have with other parts of the product. So in this case, the issuer of the loan notes. There's also, I think, a key issue here, which was an issue, was the central bank's, or the failure to inform the central bank when the issues became apparent in late 2019. So again, the central bank's view is where an issue or a potential breach is identified, you should be telling the central bank fairly quickly. And if there is ultimately a broader issue, you can always investigate that, but certainly waiting, in this case, over 8 or 9 months between identifying what is likely an issue and ultimately telling the central bank was a serious issue, which was probably an aggravating factor which encouraged enforcement in this case. Now, ultimately, the investment manager in this case was put into administration and wasn't actually a regulated investment manager in any event. And then all, as I mentioned, all the assets involved here were transferred across to another Waystone entity. So bit of a cautionary tale just in terms of due diligence, etc. The next point, or the next subject we'll touch upon very briefly, is just the ESMA MiFID II and MiFIR review. So what's going on here is that following kind of revisions to MiFID II and MiFIR, kind of mid or early last year, so they were implemented in 28th of March 2024, and ESMA has been going through effectively an overview, consultation process and report process around a lot of the level 2 measures under the legislation. So you can see there that's ESMA's overview in terms of the timelines. They were at this stage produced quite a number of final reports, and we're due then another kind of set of final reports later in the year. To date, they've covered off 5 final reports, and I don't propose to go into a huge amount of details on them. They're quite technical, but worth looking at if they touch upon obviously your business, your operations. So first one's just in terms of equity transparency, and they are enhancing pre and post trade transparency requirements for equities. There's amendments to certain of the technical derivatives for commodity derivatives. Particularly of note, I suppose, is that the position management controls those are going to apply for all trading venues, and historically they only applied to regulated markets. On bonds, structured finance products, and emissions allowance, they're again increasing pre and post trade transparency. So you can see a bit of a theme here in terms of the approach. And they're also looking to establish a reasonable basis for market data fees, kind of calculated based on the costs of production and dissemination of that market data. The last couple of final reports are on kind of single volume caps, systemic internalizers, and circuit breakers. So moving to a standardized template for systemic internalizers to notify competent authorities, and move from a double volume cap to a single volume cap for equities trading and reporting. And then lastly, new requirements for trading venues on the establishment of circuit breakers to maintain orderly trading during periods of high volatility. The last one, which is effectively a draft RTS, is on standards and criteria for establishing, assessing effectiveness of investment firms' order execution policies. And what it does is aim to address some of the shortcomings in terms of the current implementation of order execution policies, particularly where there is only one execution venue that's used to execute client orders. Otherwise, I mean, as mentioned, all of these are kind of in final report stage. They will need some finalization in order to be implemented effectively, and they're quite technical, but it's worth keeping an eye on them in terms of when they will come into effect. Separately, another consultation which is ongoing at the moment is the Central Bank's Fitness and Probity Consultation, so CP160. So this obviously follows out of the Fitness and Probity review that the Central Bank carried out in 2024, and that kind of followed on from the case before IFSAT, so the Irish Financial Services Appeal Tribunal, which made certain findings in respect of the central bank's broader fitness and probity process and procedures and the fairness or otherwise of those assessments. So the central bank obviously has produced the final report on the implementation of those recommendations, and in line or in parallel with that has now launched a consultation paper on broader amendments to the fitness and probity regime. So it was very recently published, and will close then on the 10th of July of this year. So if you do have any feedback on the proposals, do feed them in. The kind of key proposals that they've set out are effectively looking to provide additional information to applicants to assist with the assessment. So that's things like guidance on kind of qualifications, experience, time commitments, and role summaries for the specific PCFs. A bit more guidance on what are potentially there in terms of conflicts of interest and collective suitability, and the relevance of past events. So kind of clarifying that, look, if something has happened more than 10 years ago, it's obviously going to be less relevant to the current assessment. They have published draft guidance or consolidated fitness probity guidance now, and they've included some additional expectations around the inherent responsibilities under SEER and the roles for certain PCFs, expectations around heads of functions and levels of knowledge, experience, time commitments, etc. There's also going to be, and I think this is probably one of the more significant changes from a PCF perspective, a consolidation and simplification of the list of PCF roles. So obviously currently there are some what we term generic or general PCF roles that will apply across all sectors, but there are otherwise then sub-sectors or sector-specific roles. They're going to remove those, get rid of them other than credit unions, and then we'll undertake a more substantive review of the list of PCFs together with the SEER review in 2027. So together with the consultation paper, they also published, as I mentioned, a report on the implementation of the recommendations arising from the 2024 review. And some of those additions will include additional internal governance processes from a central bank perspective. So there'll be a new fitness and probity unit and a new specific decision-making committee, again, aimed at improving kind of the fairness and transparency of the procedures and the gatekeeping role. There will be detailed invitations for interviews, so people will have a much better understanding when they go into the interviews of what will be involved in them and what they will be asked during those interviews. A limit on the time of those interviews, which obviously I think, certainly having sat in the room in some of those interviews myself, they could tend to go on for 5, 6 plus 7 plus hours, which can be very tough. And so a commitment to kind of reduce that, and obviously a requirement to provide feedback on the interviews and keep all discussions on the record. So I think obviously some of the discussions were not provided on the record, they were off the record, but that then made it challenging to rely on them. Next topic, and conscious we don't have a huge amount of time, is the EU AML measures. I don't propose to go through the actual legislation itself because I think most people are broadly familiar with it. It was obviously formally adopted last year in May and will come into effect next year, or sorry, the year after next in 2027. The three key elements to it are obviously the single rule book, so the AML regulation, moving the vast majority of AML rules and requirements up to a regulation at an EU level rather than directives. The sixth AML directive, which is going to deal with kind of procedures around sharing of information between member states, and then the establishment of AMLA, which, as you may be aware, has already been set up and has started some of its work. Obviously, located in Frankfurt, and Hans Derval Roland has been appointed as one of the directors of AMLA, so she will be taking up that role, or has taken up that role. So far, in connection with the new AML package, they have produced a number of guidelines, and that includes, in the first instance, EBA guidelines on policies and procedures for financial sanctions controls. So one of the key elements built into the AML regulation was a requirement for firms to have in place appropriate policies and procedures to deal with and monitor and screen for financial sanctions. Obviously, previously firms did have those in place, but there was no clear basis for it under the AML legislation. Now there is. Those guidelines are going to apply from December 2025 and will effectively require firms to put in place effective screening systems, clearly define the data to be screened, make sure that there is regular screening, make sure that they properly calibrate settings of the screening system to lead to unambiguous identification and test those screening systems, and make sure there's policies and procedures to investigate alerts appropriately, refrain from providing services before coming to an informed decision, and obviously then suspend any transactions where there are identified. And then the final one's obviously clear reporting to the central bank, and if necessary, use derogations under the relevant financial sanctions legislation to actually carry out a particular service. The EBA is also in the process of consulting on a number of other OTS in connection with the AML package. So firstly on risk assessments, looking at the inherent and residual risk profiles of obliged entities, so designated persons, on direct supervision. So one of the key changes from a legislative perspective is that AMLA will have direct supervisory oversight of certain large and higher risk entities. Customer due diligence. So again, hopefully we get a bit more guidance in terms of a consistent approach across Europe, which will be helpful. And lastly, on enforcement. So the deadline for submission on those consultation papers is the 6th of June. So again, I'd encourage everyone to go and have a read through, and if there are relevant points to feed those back in. I'm sure industry will be doing the same. And then the final OTS are due to be published later this year in October. So very briefly, coming to my final topic is FIDA. So that's the Financial Data Access Regulation. and that was published back in June of 2023 by the European Commission. And what it does is, at a very high level, aims to provide a mechanism to allow customers to share financial information amongst different operators. There will be effectively kind of data access requirements in respect of certain products and for most financial institutions and providers. It's going to include a broad range of data. So I suppose most importantly, it will include investment products and will apply to investment firms, and ManCos will be subject to this. The key overview of mechanisms, key overview will be that essentially there will be a mechanism put in place to allow customers to request a data holder, so that would be a financial institution, to make their data available either to the customer or to a data user. And the data user will be other financial institutions or specific authorized data users. Permission can be withdrawn, and effectively there'll be a data sharing scheme which will allow people to provide the data and share it amongst institutions. The ultimate aim of this is to drive a more data or to have a more data-driven financial services market, allowing customers to effectively get better products based on more specific data on their actual activities and financial data. So just a few things to note in terms of impact. As mentioned, it kind of aims to improve price and quality of financial services, but protect against anti-competitive behavior. There's kind of risks associated with collecting this data. So obviously there'll be a key focus on customer permissions around this. There are still some questions around its interaction with other pieces of legislation such as GDPR, and it's worth noting that the concept of permission in FIDAR is not aligned with consent under GDPR. It is broader, and one of the kind of key reasons for that is FIDAR will apply more generally than just to personal data. It will apply to certain corporate data as well. Obviously, corporate customers will be covered by it. From a financial institution perspective, there will also be a need to review how data is currently collected and maintained, and how it may be possible to actually effectively share this data. And certain member states or between themselves are looking at the potential for data sharing schemes to be put in place. Still not clear if there'll be a European one or if it'll be done kind of more locally. I heard some of the Nordic states were looking at a potential sharing there. And then there's obviously potential opportunities in addition to the costs there for financial institutions, because they'll be able to use this data from multiple sources, which should, and this is obviously the fundamental aim of FIDAR, assist with potentially more innovative and data-driven financial services products for customers. So that was my very quick overview of some of the headline issues that we are seeing currently in asset management, particularly in terms of legal and regulatory developments. So at that point, I might hand over again to Gary just for any questions and answers. Thanks.
Thanks, Christopher. Very comprehensive view of the landscape. We just had one question come through, actually, and it relates to the final topic, the Financial Data Access Regulation. And it's around it. There's been talk of the abandonment of it, and the question is, how likely do we think it is, or is there a view on that?
Yeah, so I think there have been some discussions. I think particularly some of the certain institution and industry bodies have given a fair bit of pushback in terms of FIDAR, given obviously the potential for opening up of data, some of the potential issues with that from a systems perspective. But then on the other hand, some of the smaller players and certainly the startups view this as a very positive measure. And I think that there has been a change in the European kind of executive, so we can't rule out a complete change. But I think as far as we're aware, it is still on the agenda and should proceed. And I think we would anticipate it probably coming into force sometime end of 2027. Although obviously we'll see if they start getting up and running. As I said, as far as I'm aware, I think certain regional bodies have started looking at potential for regional data sharing schemes anyway. So I think there is still enthusiasm for it as a project, notwithstanding some negative feedback in terms of the overall proposal from certain industry bodies.
That's very helpful. They are all the questions we have, and we're right on 10:30. So I think we'll wrap it up there. So just to say thanks very much to Christopher for the presentation today and the answers to the questions, and thanks to everyone else for attending the webinar and indeed attending any webinars you attended in the series. So we look forward to hopefully seeing you again on a future webinar or meeting you at one of our in-person events. So thanks very much and have a great day.